Well, here we are. Greetings again. Lesson 19. Let's take a look here at the lines of defense, the scene of the crime, defense on the facts, motion hearing, the jury, the appeal, and unable to pay because of Article 1, Section 10. I've pulled out Lesson 9 again, and remember that starting here, now this is the fourth set of 6. We've gone 1 through 6, 7 through 12, 13 through 18. Now we're going to go 19 through 24. Now we're going to get into more of the nitty-gritty of the courtroom procedure. Now what you need to know at this point in time is you have to have a pretty good understanding of Supreme Court cases and how they work, the exclusionary rule. I want to just take a moment and run through some of the things at this moment in time that you should know by this stage of your development. You should have a pretty good grasp of your status. You know that you're a slave on the good ship Idaho, and that you need to improve that status and get out of the contracts, because we're going to talk about this case today, and a person who's under contract would be guilty of this charge under Lesson 9 if he were in some kind of corporate capacity with the state of Idaho. We talked about the scene of the crime, the exclusionary rule. You should be able to handle the scene of the crime professionally without giving any information to your opponents, and you should be there getting admissions and confessions from policemen. You should have gone through Miranda versus Arizona, and you should be familiar with the Mutt and Jeff routine and how you may be put in a lineup and how it's going to be presumed that you're guilty and that you've done this. You haven't paid your taxes or whatever it is. The jailhouse scene. You should be steeled, hard, knowledgeable. When you're put in jail, you should be spreading stark terror among the jailers, instead of you being the victim of stark terror while you're in the jail. Search and seizure. By now you should have read 100 search and seizure cases from the Search and Seizure Law Report, so that you have a good understanding of what is and what is not usable against you in court, and how to keep from having or keeping upon your person, your business, incriminating evidence that could be used against you. Arraignments. You should be knowledgeable and familiar by now what an arraignment is and how the arraignment and plea works. There's a sample of an arraignment and plea in this lesson. And what the key issues of the arraignment and plea are, how to keep from granting jurisdiction to the court, how to make a special appearance, etc. Courtroom procedure here. Let's see, I was on, let's see, now I want to go to Lesson 7. That was jurisdiction. You should understand by now what jurisdiction is about. What courts do have jurisdiction and which courts do not have jurisdiction. Separation of powers. You should understand the doctrine here that our founding fathers put together, and why it is that we have this Republican form of government, and how that Republican form of government can work for you in the courtroom if you make it work. But an individual has to make it work for himself. Service of process. Things like citations and complaints. The courtroom procedure. There was an example of a courtroom procedure in Lesson 10 acted out for you so that you know what to expect, who says what and when, sort of like a Perry Mason show on TV. Property and rights. You know, there is no private property in America, and what our goals and ambitions are is to restore private rights to private property, and why it is you don't have private property. And the rules of the game, and we talked about the rules of procedure. You should be familiar in the state wherever you are of the criminal rules and misdemeanor rules of procedure in your particular district. Motions and briefs. You should be familiar now with what motions and briefs and arguments are in affidavits. If you don't, you need to review those lessons, because from now on when we talk, we're going to be talking as if you were a knowledgeable pro se, and we're going to be talking to you as if you're a professional. In the first 18 lessons, remember, we're talking philosophy and basics. When we get into the last 12 lessons, we're going to be talking about law and how that court works and why it works that way, and all of the technical moves that you're going to be making one after another, objections, etc. We talked about motions in lessons 13 and 14. You should be pretty familiar with motions, how they work, and you should have read a lot of them. You should know how to write them. If you can't write a motion, you should sit down with a yellow pad, just like we've done when we did lesson 13 and write out a physical motion, because that's a letter to the court. You know, I've got students here that have graduated from high school and have a year or two of college that cannot write. They have to print. I don't know where that got started, but I'm telling you, friends, there's 3,000 students, you may have seen this on TV and read it in the papers down in Florida. These 3,000 high school graduates couldn't pass a simple literacy test. Well, if you're one of those, then you're going to have to get back to some basics. You're going to have to be able to write. You're going to, you know, I guess even if you can print, I guess that's satisfactory for what you're doing, because you're going to be typing everything out. But you know, there comes a point in time when you're going to have at least some kind of basic understanding of the world around you and get out of this basic, or this fundamental, I'll use the word fundamental, dream world that I think most of us have been in for years and years. And that lesson down there in Florida is just unbelievable. Okay, then the money issue. We went through Article 1, Section 10, Federal Reserve notes, obligations, legal tender. Those Federal Reserve notes are theft. We're dealing with one another by stealing from one another. And the guy that perpetrates the theft is a guy that counterfeits real wealth. You know that dollars aren't money. We talked about the IRS scam and why it is that the IRS collects tax on their notes that they pass around from the Federal Reserve System. And we talked about statutes. What is and is not law? What's under color of law? How to read a statute and why a statute says what it says. You know, if you can't write, we'll presume that you probably can't read. And then the last lesson we did was the common law, equity, chancery, and we talked quite a bit about the traffic court, maxims of equity, etc. So you should have a fundamental understanding by now of when you walk into a traffic court with a driver's license, you're guilty. You are a regulated person in a regulated enterprise, and you may beat them on procedure, but you're not going to beat them on law. And, of course, now in Lesson 19, we're going to talk about what is procedure. How do you beat your opponent on procedure even though you have a driver's license? Now, let me just give you a little background for a moment. Let's talk about the two ways to win in the courtroom are procedure and law. Now, let's just think for a second what law is. You go into the courtroom and you've been charged with failing to register as a resident alien last January at the post office. That's an easy one to win because as a matter of law, you're a natural citizen, and so you're going to write 3 or 4 motions. You're going to plead the statute, and you're simply going to say, I'm not one of them animals. Okay, you can win that one on law. What if you are a resident alien, and what if you didn't register last January? Okay, you're not going to win on law. Because if your opponents can show that you're from Greece, that you're not naturalized, that you don't have any kind of paper or permit, they're going to deport you because you're guilty. Now, if you'll notice down in, I think it's in the prison in Atlanta, maybe even over in, I don't know, Nashville or Tennessee or Arkansas, they're holding a bunch of Cuban and Haitian refugees that are trying to get into this country under certain immigration laws as political prisoners or victims of political repression. And there's laws and statutes, of course, that cover that. So that's called code or fact pleading. What you need to do there is to pull the statutes out, which is what we're going to do here today, and to read the statute, and you're going to try to win on procedure. And the procedure may be that, well, I was born in this country and then taken to Cuba, and then I came back into this country, and therefore I'm a natural-born citizen, but you're going to have to prove that. Those are facts surrounding your case. All right? Now, let's say that you've got a driver's license, and you're out here driving, and you get a ticket for speeding. All right? As a matter of law, the court of original jurisdiction is the traffic court. There's nothing wrong with that. The problem was that you volunteered into that regulated enterprise. Now, in some cases, if you're using the roads for trade, commerce, business, or industry, as a matter of law, you need to be regulated. I don't have any problem with that. You know, if I go out here and buy a truck, and it's, I put $5,000 down on it, and it's owned by GMAC, and then I go over here to a broker, and he gets me a load of lumber from the ABC Lumber Company, and I'm going to deliver that to the ZYX Building Materials Company in Houston, Texas, and I'm going to be driving across state lines, and I'm going to be taking somebody else's wealth and delivering it to somebody else 3,000 miles away. We have to have a methodology whereby we can regulate those trucks in interstate commerce, that we can license and tax them, and that we've got competent drivers that are driving them up and down the roads and things like that. I don't have a problem with that, and if I did, it would just be too bad, because the police powers do apply. Police powers existed long before the advent of our Constitution, and I'm not even sure that I oppose the police powers when they're properly used upon the proper subjects and subject matter. It's when our government uses the police power to tax, and the police power for political repression, and the police power for regulation and control of subjects or natural citizens that are not the proper subject matter or the proper individuals to regulate, that I have a problem with my judicial system, my executive department, and my legislative department, because I have natural inalienable rights. And so the first thing now let's take up is this thing of Lesson 9. Pull out that case, and let's take off here, and I'm going to show you how I went through this case and how I pled the statute item by item, and how I filed the motions, and what it was I said in those motions, these fundamentals of the lines of defense. I call them lines of defense because there's many of them. And I kind of liken it like this. Let's say you're out here on a battlefield, and over there's 10,000 of the enemy troops, and over here on your side there's 5,000. So you're outnumbered 2-1. Now, a friend of mine told me, and Bob Hallstrom's a fellow, and he told me that when they're in the military, they attack with 3-1. But if you're outnumbered 2-1, the advantage is in your favor, because your enemy needs 15,000 men to attack 5,000. So, if you get right down to the nitty-gritty in this strategy, I'm in the power position. I can't attack, but they don't have enough men out there to attack and beat me. So, what I'm going to do is I'm going to set up some lines of defense. First thing we're going to do is we're going to dig in, and we're going to get a line of defense or a perimeter around our area there, so that when they attack us, we can be shooting them down. When you are the defendant, you're the man who's in the defensive position. It's going to require 3-1 odds or 3-1 superiority in order to beat you. And that's why we estimate that. That's another reason why we estimate that. Even if you're guilty, the odds are in your favor by 75% to 25% of victory on the defensive move. Now, if you know and understand Miranda and you shut your mouth, didn't say anything, and shut up, your chances of winning now go up to 90%. Because they will not be able to use anything that you are going to say against you. You will deprive them of all of the ammunition, all of the offensive material to convict you. And so, for that reason, then, your first lines of defense come where? The very first things that you need to do are done not in the courtroom, but out at the scene of the crime. Let's think about this for a moment. Here you are at the scene of the crime. Somebody knocks on your door, and they've got a search warrant there, and they're coming in to search for, well, let's pick something, heroin. All right, they're coming in to search for heroin, drugs. And if you wonder why I keep picking on drugs, it's because drugs today are like alcohol was in the 20s and 30s, and most all of the new cases that are coming down in searches and seizures talk about drugs. And that's what you saw in search and seizure law report. All right? Knock, 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 bang, bang, bang on the door. Open up, this is the police. All right, now, first tip-off is you've got the police, you've got your government standing at your door. Do you have any witnesses in the house? If you do, don't go open the door until you get 2 or 3 witnesses, 1 witness, 2 witnesses, whoever's there, standing at the door. as you open. Now you make the exclusionary rule demand. What do you want? What's your probable cause for coming onto my property and knocking on my door? I have a warrant here signed by Judge Schmedley, and we're coming in here to search for heroin, and we're looking for all of this contraband. And this is a lawful warrant, and here it is, and we're coming in. No! Let me read this warrant. You don't have my permission to come in here. Now, if he pushes you out of the way, be careful at this juncture. If he does have a lawful warrant, he's going to come in anyway. And if he doesn't have a lawful warrant, he's going to come in anyway. Don't let him in. Don't grant him permission to come in, because if you grant him permission to come in, you've waived a valuable right. And it's more difficult to recover than it is to prevent a loss of your position. Now, when I was dealing with OSHA, what I would do is to stop them and then look at it. Is this warrant returnable to a judicial officer? Is there an affidavit in support of it? Who is the person who swore that they know there's heroin in your house? Get his name down. It's Joe Baloney. Right away you can tell, why, Joe Baloney doesn't even live here. Joe Baloney doesn't know what's in this house. So now you've got an attack on the affidavit. Because remember, under the exclusionary rule, when you get into the courtroom, you need to know who Joe Baloney is, so that when you come to arraignment, so that when you come to the first motion hearing, when you come to the exclusionary hearing, you can subpoena him. You don't know how many people there are that have been burst in upon. There isn't even an affidavit supporting the warrant. And furthermore, maybe it's an administrative warrant. Maybe it's not even returnable to a judicial officer. If that's the case, now you've got grounds for a Title 42 suit. Now you should be thinking offensively. How many of you policemen are there? What are your names and addresses? You're Officer Smedley, Officer Jones, Officer O'Houlihan. Don't you recognize that this warrant is illegal and unlawful? Don't you see that it's insufficient? Can't you see there's no affidavit in support? Is this an exigenic search? Are you making this search on your authority? Which one of you three men here is making this search? Who's taking responsibility? And here's your witnesses here. Get your yellow pads out. Officer Smedley and your witnesses should be going around the table over here. Now let's suppose that they come in anyway and they seize some heroin. What if they come in and they don't find any heroin? What they find is Uzi submachine guns and hand grenades. Or they come in and they find that you've been remodeling your house here and you don't have a building permit. I mean, who knows what they're going to find in there? If the warrant says heroin, then they better be going in there and they better find heroin. Everything else can be excluded. And if this is an unlawful and an illegal warrant, if this comes under, remember this key case here on page 26, the cunning coercion. Let me just quote that to you for a moment. What if they're trying to cunningly coerce you into waiving your rights? In this case called United States versus Minker, what if this warrant is like this phony summons from the IRS? And they use those all the time. I had 3 warrants served on me while I was running the Atlantis Company, and all 3 of them were phony warrants. None of them would hold up in court. Fortunately, I knew enough to keep the guy out. And we attacked the warrant, we attacked the information that they got from the warrant, and we won. Now that's first line of defense then, when you're talking about a search warrant. The worst that can happen is that he's got a lawful warrant signed by a person who has personal knowledge of the contraband in the house, and he's going to come in and seize the contraband in the house and use the evidence against you lawfully and legally. But at least make him dot his I's and cross his T's. Now, once that's behind you, and in this particular case at Lesson 9, I didn't have a search warrant here. It wasn't necessary. All right? Let's take a look then at another line of defense. They arrest you and they take you to jail. Okay? Now, you're in the jailhouse scene. Well, now comes Miranda versus Arizona. Now they're going to pull the Mutt and Jeff routine. They're going to put you in a lineup. They're going to identify you. They're going to charge you with 16 felonies or 47 felonies. They're going to threaten you with death, the hangman's noose. Maybe they're going to threaten you with 197 years in the penitentiary. and only 10 off if you're in there on good behavior, something like that. They're going to lie to you and give you false legal advice. I wonder if we could prosecute a sheriff's deputy for giving false legal advice under Idaho Code 3-401 or 3-420. I mean, after all, if a policeman gives false legal advice, isn't he practicing law without a license, and shouldn't he be prosecuted? That's a good line. Yeah, that's right. That's a heck of a good line of defense. Attack. If you get false legal advice while you're in jail, and I've had policemen give me legal advice in jail and try to deceive me into giving up my inalienable rights, try to cunningly coerce me into waiving my rights due to my ignorance. All right? There's another line of defense then right there in the jail. You demand all of your rights at all times. You demand counsel. You demand a Fifth Amendment, what you do is you demand pen and paper to write a writ of habeas corpus pursuant to the Fifth Amendment. You've got to be the belligerent claimant in person. If the jailer doesn't give you the pen and paper, that's an issue. If he doesn't allow you to have counsel, that's an issue. Okay? So you assert your rights in the jail. You know, there's a fellow down in Pocatello. I don't remember his name right off the top of my head. Just heard this story the other day. He's a relatively new student within the last year or two. And they arrested him and they took him down to jail. I demand that you take me to a magistrate pursuant to Idaho Code 49, 1109, and 1115. And I demand all of my rights, and I demand counsel. And pretty soon he was so obnoxious and belligerent there for so long that the jailers got a little nervous, and so they called a judge, and they said, what are we going to do with this guy down here? Well, let him go. But we don't have his fingerprints. You don't need his fingerprints. You know who he is. Get him out of that jail. Why? Because they know that there are citizens down there that are aware of their rights, that they're aware of Powell versus Alabama, and they know about Davis versus Mississippi. And they're not going to sit there and cry, and oh my gosh, I'm in jail, and I've got to call my wife, and I'm going to miss dinner tonight. And this guy's not concerned about missing dinner. This guy's in there. Give me a pen and paper so I can get some Title 42 information here. What's your name, officer? Are you doing this on your authority? Why did you arrest me? Why aren't you taking me to a magistrate? You see how that works? He's bringing forth statutes. He's making demands. He's not sitting in there crying in his beer. And pretty soon they said, hey, let's get this guy out of here. They turned him loose. No bail, no bond, no signatures, no nothing. Get him out of here. Why? Do you think policemen want to be sued under Title 42 once, twice, 3 times a year? Can you imagine the stark terror that you generate in your public officials when they know they're dealing with a citizen and they're not dealing with some punk, some dumb drug addict who's walking up down the streets committing common law crimes? All of a sudden they're talking to a sovereign out here who's telling them, I want you to know who you work for, boy, and get your feet off my table. And you get me a pen and paper in here, and you get Judge Jones on the phone over there and tell him who you got in here. You know, when people start dealing with their public officials like that, we're going to have Republican government, and we're going to have grand juries, and we're going to have public prosecutors. And it isn't going to take too long. I don't need 50 million people out here to march up and down on Washington or send letters to the editors. I just need myself in the courtroom. I just need to be a belligerent claimant who walks into the jail and says, boys, I think you got the wrong man in here. And you know, pretty soon you get 2, and then 4, and then 8, and then 16. And all of a sudden, a citizen gets thrown in jail and he says, not giving you my fingerprints. Get a court order pursuant to Davis versus Mississippi. Oh, yes, sir, Mr. Gordon, we understand your position, and we're not going to take your prints, and we know who you are, and blah, blah, blah. And see how that comes down? All right. Now you're in the jail. Now what's the first thing you do if they lock you up? Here's another line of defense. See, right there in the jail, you've got Powell versus Alabama. You've got a number of cases where the Supreme Court has said, Argersinger versus Hamlin, you can't lock a man up if you deny him his right to counsel at any meaningful hearing. Miranda versus Arizona, you've got to give him his Fifth Amendment rights, and you've got to give him that lawyer. Okay? I've never, in never yet had them obey the law in the jail. When you get right down to the bottom line, if they deny you counsel in jail, that's an appealable issue to haul off to the Supreme Court. And that's what you want them to do. You know, one of these days these guys are going to start obeying the laws, and it's going to be tough to beat them. You know, if those public officials out there would obey the law as it's set down, why, what would you do procedurally? You see, you wouldn't have any procedural matters to object to. And it's when they violate your rights that you win your case on procedural matters and reversible error. Now, when it's a matter of law, that's where you're not even guilty. You didn't do anything. And so you act in or under a brief or a motion or a legal document that's called a demurrer. And the reason for that is you say, well, certainly I refuse to give the officer my fingerprints and my mug shot. And he charged me with obstructing and delaying an officer in the pursuance of his duties. So what? I have a right to assert my Fifth Amendment rights. Now, you see, our argument isn't on procedure, it's a matter of law. Let me give you an illustration of that. Here's a line of defense. I don't break the law, and I don't tell people to break the law. I'm telling you policemen out there, you guys start obeying the law. Well, the other day, it's not the other day, I guess it's 3 or 4 months ago, I had the pleasure of spending a night or two in the Palmer Hotel here in Ada County, Idaho, and the bellboys running up and down the halls kept coming to the door, knocking on it and saying, Mr. Gordon, would you like to be booked? And what he was saying is, Mr. Gordon, would you like to be registered here at our hotel? No, I don't want to be registered at your hotel. I wanted to stay at the Holiday Inn, and now you've brought me over here to the Palmer Hotel against my will and over my objection. And I'm not going to sign the register. I'm not going to register here at your hotel. Yeah, these policemen, they run up and down the halls. They bring you meals right in your room. Actually, that Palmer Hotel here is probably better than the Holiday Inn. The rates are much better. Holiday Inns are charging $30 to $50 a night. And in addition to that, they don't have room service on meals. And the Palmer Hotel also has kind of what they have in Europe. What they have there is they have 8 or 10 people that sleep to a room, kind of dormitory style. That's what they have here in Ada County. And then they have these uniformed bellboys. They bring you your meals in the room. They bring you magazines, and they let you out, and you have racquetball and all kind of 1 hour a day. Of course, it's not quite as good as the Family Fitness Center, but it's kind of similar to that, and that's what we're paying for here. Well, anyway, these bellboys, they kept running up and down the hall, and they kept asking me if I wanted to be registered, and I said, no, what I want you to do is obey the law. I want you to get a court order, and as soon as you get a court order, I'll show you how to take my fingerprints. I'll be happy to give you fingerprints and photographs and whatever it is you want. But I've got to have that court order because that's the law, and that protects my rights. Well, I was in there for a couple of days, and they never did get a court order, so I'm assuming that none of the judges here in our district wanted to order me to register at the hotel. And so out of frustration, not knowing what else to do with me, they've got to do something because I'm the only guy that checks in and out of our local sheriff's hotel without registering. All the rest of the people register, and they don't like that, and they get real upset about that. And I'm sorry, I probably would have stayed at the Holiday Inn, except that they insisted that I stay there, and I couldn't complain because they didn't charge me any rent. They take you out there, they feed you, and they give you a nice nifty orange suit, and they bring you meals in the room. They do all these things, and they don't charge anything, but they want you to register, and I didn't want to register, and so they kept a list, and they kept putting down on there the date and the time and the place that they asked me if I was ready to be registered at the hotel. They call that booking there, registered, and I kept telling them, no, I don't want to be registered here at your hotel until I have a signed order or invitation from a judicial officer. And every time they did that, I took out my yellow pad and I wrote down the date, the name, and the time. And I said, okay, I was in a room, in a dormitory style room. They do have private rooms out there also. They call that solitary confinement. in Palmer's Hotel, it's solitary confinement. In the Holiday Inn, they call those private rooms with bath. Now, I don't know whether they charge extra or whatever. You get better facilities over there in the private rooms at the Holiday Inn. They're much larger and have king-size beds. The Palmer Hotel doesn't have any king-size beds in it, not a one. I think that's why it's probably less popular than Holiday. So if you come to Boise and you're looking for a place to stay, there's, the Holiday and the Ramada are the two better places to stay because they do have queen and king-size beds. Now, I'm not too particular. Whenever I'm out in the Palmer Hotel, I like the dormitory style because there's witnesses in these dormitories. When you're in solitary confinement out there, of course, you don't have as many witnesses. So, this Officer Smedley would come down, he'd say, "All right, Gordon, are you ready to be booked in yet?" "Oh, no, sir, not unless you have a court order. Have you got the court order yet?" "All right, smart guy." And I don't tip any of those bellboys out there in the Palmer Hotel, let me tell you. They're pretty rude and they're pretty crude, and I wouldn't give them any tips. And the room service down there is kind of poor also. They do give room service, but it's not too good. And they're rude and they're surly and they're caustic, and I just don't really care too much for them. So what I do is I take down their name and their badge number. They have little badges. So get their name and their badge number, and then get the date, the time, the place, and then whoever's in the room with you. Those are called inmates in there. Or are they called roommates? Well, I don't know what you call them. Anyway, they're in the room there with you, and then you write down their names so that they can testify when you get in on the courtroom floor as to whether you obstructed and delayed the officer. And you ask questions like, well, now, how did he obstruct and delay the officer? Did he go out and grab that officer and throw him down on the floor and tie him up with his handcuffs or something? No. Okay. Well, did he get in the officer's way when he tried to walk in and go to the bathroom and the officer wet his pants? Is that what he did to obstruct and delay him? No. Okay. Well, then, Mr. Gordon really didn't obstruct or delay. What he did was he asserted his constitutional rights under the Fifth Amendment. Is that what you witnessed? Yeah, he said he had a Fifth Amendment right or something like that, like man, like, I don't really know, God, like most of the people out in Palmer's Hotel are functional illiterates, and they go like man, well, I like, they don't speak too well. But as well as they speak, you write that down. You see where your defense is? Facts, witnesses. When you walk into that courtroom, the way I see it, any case that's important enough for my government to prosecute is important enough for me to defend. Now, I got one of those charges, obstructing and delaying, and I've got 27 witnesses, and I estimate it'll take an hour for each one of them. That's 27 hours of testimony on whether or not I obstructed and delayed or whether or not I asserted my constitutional rights. And when I'm asserting my constitutional rights, the way I see it, the Supreme Court of the United States has pretty well settled the issue when they said, we find it intolerable that one constitutional right should have to be surrendered in order to assert another one. That comes from Simmons versus U.S. 390. Got it? So here I've got 27 of these witnesses, which includes numerous jailers, because every jailer that comes down there. Oh, Officer Smedley, did you ask Mr. Gordon if he was ready to be booked? Yes, I did. And what did Mr. Gordon say? Oh, he said no, he wasn't, that he wanted a court order. Oh, I see. Did you get a court order? No. Why didn't you get a court order? Well, I don't know. Well, did you try to get a court order? Well, I think Lieutenant so-and-so, did you call the judge? No. Well, thank you. You see that line of defense? We're not even in court yet. I've got my case won and I haven't even got out of jail yet. See how that comes down? Now, next thing's going to happen to you, they're going to bring you before a magistrate. They'll arrest you on Friday afternoon so that they can punish you Saturday, Sunday, and then they'll bring you to the magistrate Monday afternoon at 4 so that they can claim that they just kept you over the holiday rule or over the weekend rule. I don't know why they don't arrest people on Tuesday, Wednesday, and Thursday and bring them out the next morning. But if you carry one of these around, you will always go to jail over the weekend. So you want to bear that in mind. And you ladies out there who have husbands, when your husband doesn't come home on Friday night, you ought to know right where he's at. He's staying with the boys over at Palmer's. Okay? And that's the first place you want to call. Call Palmer's and say, have you got George over there? Oh, George, I'm just worried about him. I thought maybe he might have had an accident and been in the hospital. As long as he's in the Palmer Hotel, I'm happy as a clam. I know right where he's at. That's what we always tell people around here. Know right where he's at. You know, then people get real upset and they say, oh, you went to jail? Oh my God. And they just get real panicky over this jailhouse scene, you know. And they point their finger and say, I'm in good company. Do you know some of the better people in world history have been in jail? Yeah, that's right. Guys like Paul and Peter and Simon and Ezekiel and Jeremiah and Joseph Smith and Alexander Solzhenitsyn. And I guess if we just sat down here and figured out all of these famous personages that have been in jail, Adolf Hitler, gosh, he even spent a couple of years in jail. You know, some of the better people in life have spent a little time in jail, not to mention our founding fathers. So, when you're carrying your Constitution around and your local prosecutors and jailers and others are using the word Constitution like it was a four-letter word, I think you can be real proud of that. I am. I go to jail and I say, gee, I'm in here on constitutional grounds. And I'm real proud to be here, and thank you very much, kind of like Minnie Pearl, you know, just real proud to be here. All right, so now the next thing's going to happen. Watch this next line of defense. Now they've got to bring you, at some point in time, they have to bring you to a magistrate, don't they? Well, I think they do. They're still practicing that here. So on Monday at 4 o'clock, you'll come up to a magistrate, and he'll say, now, Mr. Gordon, you've been charged here, and I have a complaint in front of me here, and it says here that this is criminal, and personally appeared before me this 9th day of August, 1982, Timothy Gass, in the county of Ada, who being first duly sworn complains and says that George Gordon, on or about the 9th day of April, 1982, in the county of Ada, state of Idaho, then and there commit the crime of malicious injury to property, which is a misdemeanor violation of Idaho Code 18-7001. The said crime being committed as follows, to wit, that the said defendant George Gordon, on or about the 9th day of April 1982, in the county of Ada, state of Idaho, did maliciously injure certain personal property, to wit, a pair of overalls, the property of Ada County, by taking overalls apart at the seams, all of which is contrary to the form, force, and effect of the statute in such case, and made and provided against the peace and the dignity of the state of Idaho. The said complainant therefore prays that a warrant issue for the arrest of said defendant, George Gordon. You know, this is the judge. Mr. Gordon, how do you plead today? Well, Your Honor, let me see. Do we have a copy of the complaint so that I might be informed of the charges and the facts of this case? Oh, yes, Sergeant Smedley, give Mr. Gordon a copy of the complaint. Thank you, Your Honor. Well, Your Honor, in looking at this complaint, I don't believe I'm going to be able to enter a plea today, and I think there's 2 or 3 reasons. First of all, let the record show that I'm a natural person and that I'm a sovereign citizen and I demand all of my rights at all times. I demand all of my rights at law under the common law. I waive none of my rights at any time for any cause or reason, including my right to time. I notice that there are some jurisdictional defects here in the complaint, Your Honor. First of all, I note that the state of Idaho is the party of interest. And since the state of Idaho is the party of interest, I believe what we have here under the Constitution of the United States is a jurisdictional problem. And the reason for that is, since the party of interest is the state of Idaho, and a sovereign citizen is the defendant, we have a civil action here, and I note that the complaint is charging a misdemeanor. So we have a civil complaint being brought as a criminal action. So the form of the complaint is improper. In addition, I'd like the record to show at this time, Your Honor, that I'm appearing without counsel, and I demand my right to counsel of my choice. In addition, Your Honor, I've been in jail for 3 days, and I've made admissions and confessions in here against my will and over my objection, and I want the record to clearly show that anything I've said, any actions that have occurred inside this jail, were done and were taken from me by force and violence against my will and without my knowledge, without my consent, and without my knowing waiver. Now, Your Honor, since there's a jurisdictional defect here with the complaint, I think I'm going to need at least a week in order to determine what these jurisdictional defects are. I think under Article 1, Section 8, however, that we're going to need a grand jury because this looks like an indictable misdemeanor if we're going to pursue this case as a criminal action. In the event that this isn't a criminal action, this court then has no jurisdiction over this case because it's civil, and therefore under $2,000 it belongs in the small claims department. I noticed that it has something to do with a pair of coveralls. The issue of whether or not the coveralls were entered into any type, or they're the product of my entering into any type of contract with the state of Idaho to purchase these or to rent, lease, or in some way use these coveralls that are alleged to be the property of the state of Idaho, I have no knowledge. So I think for these reasons, Your Honor, that we're going to need to continue this hearing for at least a week or two. But also let the record show that I'm here in this court today against my will and over my objection, that I've been brought to equity in chains, and that they have me now locked up in the jail, or that I've been brought here by marshals in handcuffs, and it was just outside the door here that they took the handcuffs off of me. So I'm not making a voluntary appearance into any type of mercantile equity. And I discount and disclaim any type of civil jurisdiction because I'm a trader at the common law. I am not a merchant and trader in equity. Now, I challenge the jurisdiction of this court on the grounds that I've stated, and I'm going to need at least 60 days to prepare my defense, as there are numerous witnesses, possibly as many as 27. Now all I'm going to do is wait for the court's response. I've entered my challenge to the jurisdiction. I've demanded all of my rights. I've set the record. I've objected to the complaint. We have a jurisdictional defect. We have a civil action, not a criminal. Do you see where this line of defense comes in? And probably one of the most important disclaimers is under the Miranda doctrine. You can't haul me into this court over here against my will, over my objection, without a lawyer. Miranda specifically dictates that I have counsel. You can't bring me into any kind of a meaningful hearing without counsel. Now the judge is going to ask me the magic questions. Well, Mr. Gordon, are you indigent? I don't want to make any admissions or confessions, Your Honor. I don't want to make any statements to this court. I don't want to make any admissions or confessions until I have counsel present. I demand my right to counsel. Well, do you want the court to appoint counsel? Absolutely not, Your Honor. I want counsel of my choice. I do not want government counsel. I don't want government prosecuting me, government trying me, and government defending me. I'm going to defend myself in propria persona, and I'm going to defend myself with counsel of my choice. The judge is going to reply, well, as long as this lawyer or this counsel is licensed in the state of Idaho, I don't have any objections, Mr. Gordon. You don't.